Thank you, Senator Rounds. Senator Booker.
Mr. Chairman, if you gracefully hold the clock for a second, because I want to respond very succinctly to something that Mr. Senator Bozeman and you said. First of all, to you, sir, I just want to say it's my first time going through nomination hearings. You have been very generous with the way you've been conducting these hearings. I think it's important that we note that, and I appreciate the number of rounds that you're doing. And then to Senator Bozeman, I really do appreciate him adding to the line of inquiry I'm having. He referred to me as a friend, which means a lot to me. People around here, your colleagues, know that you have a deep respect for the kind of kindness and just decency that you represent. It's a level to which I aspire to but have not attained. So I thank you for that. Thank you for indulging.
Thank you.
And again, with respect to my colleague, who is a really good man, if this was between Delaware and New Jersey, I'm the upstate, I would be very happy with the agreement that it seems that you did, but you were the downstate. And so that's what I don't understand. Now, you said earlier in your testimony in regards to this matter that you have a copy of the 2003 agreement. Do you have that?
I had the second agreement, Senator. The one.
Okay, well, let's just look at the 2000 agreement. And I know you claimed in your testimony earlier that the 2003 agreement had an expiration on it.
There was a 10-year period that needed to be reevaluated. This is the second statement I have here, Senator. I don't have.
Well, sir, I just want to clarify. That it seems that that's a contradiction. There's no expiration on the 2003 agreement. It had a reevaluation, a period in which it would be reevaluated, and it was reevaluated by your state with involvement of the EPA and the involvement of Arkansas, and they came up with the same .037 standard. And if you look at the provisions of what you do have in front of you, the 2013 agreement, and I have a blow-up of page 4 of that agreement, it states that, starting here, it states that Oklahoma, through the Water Resources Board, will propose a rule amendment that removes the date to achieve full compliance with the numeric phosphorus criterion set forth in Oklahoma Administrative Code, and then it lists these two codes. And if you look at those two codes, what those two codes do, you know what they are. They set the sections of phosphorus concentration shall not exceed 0.037 by June 30th. It's removing the June 30th deadline in these two statutes. And so that's what is frustrating to me, is that this is what you're heralding as a great agreement, but you already had in your 2013 agreement. It's clear that you're doing to me, and I don't know other way of reading it in the facts, is you take a binding rule of law and you suspend it for another 3 years, allowing the more pollution to take place.
Senator, that is not, the issue here was not whether Oklahoma could enforce its .037 standard. It was whether Arkansas was going to adopt that standard on that side of the border. That had never taken place in history. That was the concern of Oklahomans. That was the concern of Mr. Fight at the Scenic Illinois River.
And so I respect that. I'm going to stipulate to what you said. I'm running out of time, sir, because I agree with you whether Arkansas was going to be able to live up to that standard. But you're the Oklahoma Attorney General. And this is what I want to say. As soon as you did this so-called historic agreement that set it back, you basically turned to the EPA with the with the power of the law of the Supreme Court and say, okay, back off of my corporations. Why do I say that so confidently? Because I pull a letter from Tyson Foods that literally 6 days after your so-called historic agreement of suspending this rule for 3 years, they're delighted. They write to the EPA and say, hey, you may have now already heard of the February 20th agreement by Arkansas and Oklahoma officials to jointly conduct a comprehensive study of concentrations and impacts in the Illinois rivershed. They're excited. They literally say compliance, however, with the 0.073 milligram has been suspended. So lay off us, EPA, under this agreement until the study process is completed. They say, in conclusion, the bi-state agreement has suspended implementation date of .037 during the term of the agreement. Industry is really happy about this and believes, in accordance to this letter, unless you're saying Tyson is wrong, they believe that what you did is give them, the EPA, with the power of the Supreme Court and the 20 years of work that predecessors of yours had done, the power to suspend that power over them to comply with the law. And so that's really what I'm struggling with. On one hand, you say that you file lawsuits against 14 people against the EPA. It's this idea of federalism, Oklahoma's sovereignty, Oklahoma states' rights. You're fiercely fighting for Oklahoma. And on the side of the polluters, and you say the EPA is attempting to do things, but then on the other hand, in this case that you're talking about, you switch suddenly to say, well, Oklahoma's water quality standard for phosphorus that has been worked on for 25 years, armed with an EPA approval, armed with a Supreme Court decision on point saying that upriver states are bound, industries believe that they're bound, but suddenly you're no longer fighting for Oklahoma, you're fighting to protect industry and on the side of industry again.
I can assure you, Senator, that industry didn't think they were bound, and I can.
Then
assure
why
you
did
that
Tyson's write the letter, sir?
I don't know. I don't know why they said that, because as Senator Bozeman indicated earlier, the phosphorus level at .037 was unenforceable on the Arkansas side of the border, and that's where the contribution was. That was the concern. And until this agreement that we have here was negotiated and signed by Arkansas, that had never occurred in the history of Oklahoma.
But sir, Arkansas was party to the 2012 scientific investigation. They're bound by a Supreme Court justice case, which I pointed out to you already, and I could read you the binding paragraphs. It had brought in by the EPA, and obviously understood by industry that they were bound by that standard. Your agreement didn't stop it. It extended the period in which people could pollute. I don't understand how that could be historic.
Senator, I think as you look at what was achieved between Arkansas and Oklahoma, you have the Arkansas Attorney General, Ed Feit, who had been involved in these issues, as indicated earlier, since 1983, trying to enforce and obtain water quality that improved the scenic Illinois River. He cited the historic results in this matter. So I'm unaware of the letter that you're referring to, but I can assure you that industry was not at all excited about .037 being enforced on Arkansas side of the border.
And I'll conclude just by saying, sir, it's clear that industry was excited about the 3-year delay that you bought them to continue to pollute. It's written there in a letter. And it seems to me the theme in your work is not federalism and states' rights, but deregulation and siding with polluters against the environment and the public health standards. And it's unfortunate to me that unless you can show me something different in the way that this actually helped to clean up the river quicker, but I just don't see that at all in the evidence and the facts that I have before me.
Thank you very much, Senator Booker.